Make sure to like, follow, and subscribe to our podcast.
Listen, do what you gotta do to keep us around, okay?
Welcome to episode 7 of Off the Cuff. I'm Darren Chohan.
And I'm Matt Butler. Now, before we get into the legal mumbo-jumbo, let's talk some NFL football.
Oh, yeah.
How unbelievable have these playoffs been?
I am so happy you asked, because that Bills-Chiefs game 2 weeks ago, I don't even have words for it.
It was good.
Was sitting there. I was texting on my phone, sitting by myself, watching the game. Then Josh Allen and Mahomes just started throwing darts, dimes.
Bombs, even.
And I'm like, I'm putting my phone away.
Yeah, it was good.
Because that 2 minutes of football had to have been the best 2 minutes of professional sport I've seen in years.
It was phenomenal.
And we watched the bat flip happen live.
Yeah.
And this beat that.
Okay, well,
You're a baseball fan, but
this is a topic for another
you're
another
right. Okay.
debate.
All right, fine. We'll park it. But
Super
Bowl's
Bowl's
going to be sick.
Super Bowl's going to be super fun.
Yeah, because the NFL playoffs this year have just been lit.
They've been particularly exciting.
All
right, back to why you guys are
fine.
watching and listening.
So first, we want to thank Marissa Sarazin for an incredible
Big
episode.
thank you. Yeah.
She came in, she dropped the mic, and gave us some really good content.
Yeah. Gave us some great content on what to sort of anticipate or plan or get, your thoughts and documents together for your estate planning and, potentially a meeting with with a lawyer about your will. And a lot of people find it intimidating to call a lawyer about their will and their estate planning, but they shouldn't be.
Okay. On that, I think I'm going to go on a soapbox for a second.
Darren's going to go on a soapbox now. Here we go.
All right.
Here we go.
So in Canada, you often see barristers and solicitors. And on our logo even, you see barristers, solicitors, and notaries under the Weaver Simmons. And a lot of people don't know what that means.
No, it's true.
And so barrister is generally a lawyer who goes to court, and as we call them litigators.
Litigators, yeah.
And a solicitor does all the stuff that a litigator doesn't. So drafting contracts, drafting wills, real estate transactions, corporate law.
Yep.
All of that type of work is the solicitor's work. And it's derived from the common law system in England, where in England, you are either a barrister or a solicitor. But when you graduate law school in Canada and get called to the bar, you are a barrister and a solicitor. And now this sounds really random, why I'm talking about this, but solicitors but lawyers themselves are not intimidating. This doesn't have to be an intimidating process.
We're service providers.
Yeah. And so just like any other professional, picking up the phone and calling a lawyer to do a will should not give you that overwhelming feeling of stress. It should be one of those things, just like anything else in life, you're planning for, and it's totally normal to call a lawyer to estate plan. And I think that, the solicitors are just like any other professional and will help you through that process and be professional and kind, and it'll be great.
And some people just find it tough to talk about planning for their death, right? That's let's call it what it is. You are planning for what happens to your property, what happens, who gets what, and how your estate will be dealt with once you die. And it's not something that people thrive in, and some people think about it later. Then they had to scramble for it, but something that you can always vary and change and modify as the years go by. So it's something that, if you want to get a will together, it's you can call our office and get one done.
Yeah, and it's, to me, really cool to see the skill and experience of our colleagues, just like we did with Zach.
Yeah, exactly.
And just to have Marissa on the show was so refreshing because I learned a lot from her.
Yeah.
And her work crosses over into a lot of what we do, right?
Speaking about crossing over, she touched upon the new changes in the Succession Law Reform Act, which we're going to take and run with today, really expand on the changes of that piece of legislation. Now, the Succession Law Reform Act is one piece of legislation among many in dealing with estates, but it's the primary.
I would say so, yeah.
Yeah, primary piece of legislation. And then after that, we're going to talk about what happens if you die without a will. That's called intestacy, and what happens to your spouse and what happens to your estate then. And then we're going to touch upon a subject that I think is a big subject in family law and estate litigation and just estates, period.
That is the common law property rights, because we get a lot of questions from people about common law property rights and common law spouses. And now what we're witnessing in our practice is that there has been a dramatic shift from the institution of marriage to people who are not getting married anymore.
Yep.
And unfortunately, the law has not adapted to that as quickly as you want it to. And so the definitions, it does surprise people because the definitions of spouses are different in each piece of legislation. We're going to get into that later in the episode. So it's one of those things where you got to stick around, and I think it's going to be really informative.
Yeah. So let's take a break, and then we're going to come back and we're going to talk about the Succession Law Reform Act, and then we'll go from there.
Yeah.
This episode of Off the Cuff is brought to you by Weaver Simmons LLP, Northern Ontario's largest full-service law firm with over 30 lawyers and 60 support staff. For over 90 years, the law firm of Weaver Simmons has proudly served the interests of Northern Ontario residents and has built its reputation based on exceptional services to its clients. For more information about the firm, please visit www.weaversimmons.com. The link is provided in the description below.
Welcome back, guys. We left off talking about the Succession Law Reform Act and what the changes were. So we're going to go into that in a bit more depth now, because I think that these changes are really important and really good.
Yep.
And first we'll start off with the definition of spouse. And you heard us talking about before the break how common law spouses don't have property rights, and we're going to get into that later in the episode. But for the purposes of the Succession Law Reform Act, the definition of spouse is that of a married person, effectively married persons. So two married persons are spouses for the purposes of the Succession Law Reform Act, except for certain provisions for dependent support, which we're not going to get into today. So the changes to this act, and the big important ones, are that now marriage no longer automatically revokes a will.
Where previously it did. So
Right.
if I had a will and then I got married, my will was automatically revoked, meaning it no longer existed.
Right, and that was a big problem in predatory marriages, which is what this is meant to target. So what I mean by predatory marriages, it's the marriages that you have a younger person marrying somebody who is dying or on their deathbed, and maybe perhaps there's some undue influence or some capacity issues like Marissa went into about, making a will or getting married to somebody who's about to die. And then once that marriage occurs, the old legislation allowed that will that they had before, which could have even been a will from 50 years ago, to be revoked. And then all of a sudden, that person no longer has a will. And if they're too old and frail to go make a will, or don't have the capacity to make a new will, that person will die intestate. And Matt's going to get into a little bit about intestacy in a little bit. And that just means when you die without a will.
Yeah. And without even predatory marriages they are a problem, but even just people who have their second marriages, people who are marrying later in life and their kids are older and they have grandchildren and they've had wills done to contemplate that. And now this happens a lot where they then get married and all of a sudden they're not aware that their will is revoked.
Right.
Which is unfortunate, really.
It leaves them in a position where their children from the previous marriage or their other beneficiaries that they've designated, could be siblings, grandkids, whoever, right? Because often remarriages, they're older and maybe they have grandkids. And so they've made those provisions, but then they get remarried. And then they don't have any of that estate planning anymore, and they're not aware of that, and we're not aware of that.
And it has been a problem.
A big problem, yeah. And so this legislation, the new changes starting January 1, are meant to target that, except for the fact that it only applies to marriages after January 1st, 2022.
Right. So if you were married prior to January 1st, 2022, and you had a will previously to that marriage, it was revoked. However, there's an exception to the exception that we just discussed, where if your will was done in contemplation of the marriage, then it's not revoked. However, there needs to be language to that effect within the will.
Right, exactly. And that's where the solicitors that we talked about earlier come in and really assist you in putting those provisions in that make sure that you're protected. You know, in contemplation of marriage, you make a will, and then that will itself is valid.
Right.
Because you've said, and they call that, the legal jargon is absent contrary intention.
Exactly.
So, you know, not going to get into the weeds on that, but talk to your lawyer if this is you, if you figure out, you listen to this episode and you're in this situation, and, you know, talk to your lawyer who prepared your first will, and perhaps you need to revisit that now because of the changes to the legislation.
There's also a very nice change where we saw, you've experienced this problem in your practice, but it's something that, you know, it's an issue that needs to be addressed, and it has been addressed with these new amendments where separated spouses, you know, married couples, and they just don't get divorced, because sometimes they separate and they just say, well, it's just easier just not to get divorced because you got to bring another application, you got to pay these disbursements and it's not horrendously expensive, but we're talking still $1,000. And some people say, well, why get divorced? There's no point to it. What happened before these new changes, though, was that if you were married and separated, you didn't get divorced, and you didn't do anything about your will, and then you were to predecease your former spouse, but you're not divorced, you're still technically married. Mm-hmm. And then at that point, the estate would just go back to the will. And if the will gave everything to your spouse that you could have been separated 15, 20 years, they receive what is bequeathed within your will.
Right. And so this goes into a little bit of the intestacy discussion, but the case that I had was where just exactly the scenario you described. This happened to a real couple where they were separated for a very long time, married, never divorced, and there was no will. And there's a preferential share that happens when somebody dies without a will.
Yep.
And at that time, it was $200,000. And what that means is that if somebody dies without a will, the spouse is entitled to the first $200,000 of the estate.
As of March 1st, 2021, however, they're entitled to the first $350,000 now.
Right. And so in the case I was dealing with, the estate was only worth about $200,000. And so the parties had a separation agreement. They had been separated for a long time but never divorced. And the law allowed the surviving spouse to get the entirety of the funds from the estate. And on top of that, control the property in the estate.
Yep.
And so this is why these new changes that Matt was talking about, they added language into the Succession Law Reform Act to say that separated spouses also lose that same entitlement as divorced spouses do.
Right. They lose their appointments and their entitlements under the wills.
Right.
So if they've been living, I'll just read it off exactly from the legislation here. They've been living separate and apart for the last 3 years. That it immediately preceded the death. They entered into a valid separation agreement under the Family Law Act. They have a court order, an arbitration award regarding the settlement of their affairs upon the breakdown of the marriage, or at the time of the testator's death, they were living separate and apart as a result of the breakdown of the marriage. So it is protecting a separated spouse who then predeceases the other spouse in not having their entire estate
in order.
Having it in order, as opposed to just being in complete shambles.
Mm-hmm.
So this is these amendments have been, I think, an excellent avenue for separated spouses, and have really clarified and solidified, estate law.
Right, and it has gone it's going in a direction which is a positive direction, in my opinion. I think that these changes that came in were absolutely necessary.
I would agree.
Because without these changes, there were so many situations that we would face that spouses, and I use the word spouses in this context, again, as married persons,
yep,
would find themselves struggling, especially when they are dealing with, one of their ex-spouses remarried, and then that person wants to provide for their new partner, but they're not able to because there's a problem with the will, or there's a problem with the estate, or something has happened in between. And so this legislation has really helped to identify those gaps in the fact scenarios that people were finding themselves in. And obviously they thought Parliament thought it was important enough to pass legislation to deal with this. And so I'm happy with the changes. I think they're great. I think that especially us practicing family law really gives us a more clear picture to advise our clients.
Yeah, and just on a practical standpoint, it just makes sense that if you were separated for like 10, 15 years, that clearly, well, it wasn't, maybe not clearly, but your intention is not to have your will stand as it was when you were married and you guys typically you make a will together. They're just mirror wills. If you get everything, then I get everything if you predecease me. So now it's going to simplify when you get separated under your current will. It'll be as though that spouse had predeceased you, meaning they had died before you. Mm-hmm. So as though any entitlements or appointments within that will, they're no longer entitled to, which I think just instead of saying I'm separated, oh my God, I got to think of all these things, sort of gives you some breathing room, and just there's not that panic of going, do I need to get this done? Do I need to get this done right away? You should. However, it does sort of foresee issues that we have seen, that you've seen in a file, where all of a sudden we're fighting over an estate that you didn't even think you were entitled to up until 15, 20 years after, and then your spouse predeceases you.
But I think this highlights another important thing to me anyways in our practice. Just get divorced. Because that would be my advice. If somebody came to see me, that would be what I would say. Is, if you've been separated for that long, just get divorced, because that's your cleanest break. That is the cleanest way to shut it down, to make sure that all of the things that you want protected can remain protected from your ex-spouse. Mm-hmm. Because then you're thinking about, in that process, making a will, you're thinking about estate planning. Then at the end of the day, you can't get remarried if you're not first divorced. Yeah. So there are barriers to remarriage, of course, and so you want to make sure that you do get divorced if it makes sense for you. But I think that in most scenarios, I am recommending to clients to get divorced.
I am too, and it's kind of surprising how many.
There's a lot of resistance.
And I don't understand sometimes the resistance. Sometimes there are benefits involved, mm-hmm. where if you're divorced, you're not entitled to someone's benefits plan. But we've had matters where they come in and they say, well, I want to get divorced now. You're going, well, when's the separation? They go, I don't know, 15 years ago. And you're going, you never got divorced. It sort of boggles the mind sometimes, because it is the cleanest of breaks. Once you get divorced, the marriage is now dissolved.
Right. And I find too, when somebody comes to me after 15 years and they want to get divorced, I've had files where we can't even find the other spouse. Yeah. And then it's another huge challenge. Like, I had one, sometimes the spouse is in the United States or in Australia or in like Singapore. We have to then figure out how to get these people personally served.
Not easy.
And then start the divorce here and get that done just so you can get your affairs in order. And so we always recommend, you only need to be separated for 1 year to get divorced. So once you settle your equalization issues and all your other stuff, just get divorced, because it is the cleanest break. And we did talk a little bit about intestacy, and I think that is another piece of information that our listeners should know about, is just make a will.
Yep.
The money investment in making a will is not significant, but it protects you and your beneficiaries and your family going forward, because you'll see in our next episode what can happen.
It can get messy
if you do not provide for your dependents and you do not provide for your beneficiaries, or if you unfortunately pass away without having dealt with your affairs.
Yep.
where that goes and how bad that gets. And estate litigation, I have to say, is one of the nastiest areas of litigation
It can be messier
that
than
I've seen. It can be messier than family law.
Yeah, because we do a lot of child custody issues, and it can be messier than that, and that can get rough. But
because
the
it's adults fighting over money and property, and it's not pleasant.
It's overtly emotional. It's
the two pieces of information we can leave you with are get divorced, make a will, and everybody will be much better off.
It simplifies things. It just does.
That leaves us with common law spouses.
Common law spouses and their rights.
And I think we'll take a break and we'll get right back into it afterwards.
This episode of Off the Cuff is brought to you by Weaver Simmons LLP, Northern Ontario's largest full-service law firm with over 30 lawyers and 60 support staff. For over 90 years, the law firm of Weaver Simmons has proudly served the interests of Northern Ontario residents and has built its reputation based on exceptional services to its clients. For more information about the firm, please visit www.weaversimmons.com. The link is provided in the description below.
Welcome back. We left off wanting to discuss common law spouses and their property rights. And like we said, this is something that we're seeing quite often now, and I think we're just going to keep seeing more of it until there are changes to the law. But inherently, a lot of people think that I'm in a common law relationship. We get separated. I have the same rights as a married couple. Darren, what's the answer to that?
Unfortunately, Matt, you don't.
You don't. And one of the main remedies in family law is the equalization payment, where for a common law spouse, you could have been together 20, 25 years, 30 years. You don't have an inherent right to the equalization of the property acquired together or even separately.
No, and it all goes back to that definition of spouse.
Yep.
And when I said earlier, the law does not adapt quickly.
No.
And so you have spouses who have been together, and I've had cases where I've had spouses together over 30 years. They call themselves husband and wife.
Yep.
They do all the things as a married couple, except for they are not married.
They're not legally married.
And so this becomes a problem when one person owns everything.
Yeah.
In a common law relationship, when one person owns everything, the Family Law Act will not protect you.
It doesn't.
And the only remedies you have available to you as a common law spouse are, ironically, common law remedies.
Yeah. Common law remedies of unjust enrichment and constructive trust.
And those are judge-made constructs. They're not legislated constructs. And so you have to then plead your case in court to make a claim against your ex-spouse. And I use the word spouse here as common law spouse, but that's not the definition under the equalization provisions under the Family Law Act.
Right, those are for married spouses, but for the married couples. Now, for common law spouses, is live together, cohabitated for 3 years, or 1 year with a child.
Correct. But that definition that Matt just gave us does not apply to property.
Yeah, property or the home, yeah.
When you are pleading your case in court against your ex-partner, let's say partner just so that we don't confuse the terms, you're effectively suing them for unjust enrichment or a constructive trust.
Yep.
And in either of those claims, you're looking for contribution back of what you put into the relationship.
Or even simpler is just simply that the other person shouldn't financially benefit from my labor or my contribution.
And then most, normal case you see about this or common case you see about this is when two common law spouses run a business together.
Or real estate.
Yeah. And so when they build this thing up from zero to a big successful business, and then they get separated.
The one spouse goes, I own the business, therefore I'm just taking it with me.
Right. And this goes back to if it's just all in one person's name,
Yep.
that spouse that is left on the outside has a really big uphill battle to climb to get access to the fruits of their labor. They actually have to go through a big exercise to prove that their contributions made that business or joint venture, which is the language you hear.
Which is the language for common law spouse, the joint venture. Yeah, joint family venture.
Joint family venture. When you see that person is trying to make that claim, it's very difficult.
It is difficult.
And there's no other, unfortunately, it requires court. There's not really any other avenue.
You can negotiate, but they can...
Right, of course. I mean, then you're looking at getting business valuations, which are expensive.
Yeah.
You have to get your expert evidence. You know, you might try a round of mediation. You might try negotiating on your own. But at the end of the day, if you have fundamentally different perspectives on contributions, which I'll tell you right now,
yeah, it's very
seldom. They always do.
Yeah,
it's very seldom people agree.
Yeah, we're like, oh yeah, you put in this much
yeah,
money.
Great,
Yeah,
I'll
yeah,
pay
of course.
you out. Yeah, never.
No,
So as a common law spouse, I think our recommendations are, you know, you just got to protect yourself and make sure you're doing that, and try to, you know, another common example is when one spouse or one partner in a common law relationship owns the home you live in.
Mm-hmm. But you've both been contributing.
You've both been contributing to, let's say, renos, or you pay them, you know, you pay half the mortgage, but your name's not on title.
Yeah.
If your name was on title, then the status of your relationship doesn't matter.
Yeah.
Because your name on title to that property gives you the right as an owner
Yep.
to trigger even the harshest of remedies, which is a sale of the property, if you cannot come to some agreement.
Yep.
But as a common law spouse, partner, you do not have the ability to trigger a sale of the home. Whereas a married person, under the provisions of the Family Law Act,
Yep.
has a right to force the sale of the home.
Yep.
The matrimonial home.
The matrimonial home. And that's another thing where under the Family Law Act, married spouses have a right of possession, notwithstanding the ownership of the home.
Right.
So if you don't own the home but you are married, you have every right to occupy the home. Obviously, there are exceptions to that. However, as a common law spouse, if you're not on title, you don't technically have the right to remain there.
No, there's no occupation rights.
Which can be very shocking to a lot of people to hear that.
It's super frustrating.
Yeah.
And having that conversation as counsel to people, you know, you see people's sort of faces just drop when you tell them that.
Yeah.
Because they've been so invested in this relationship for however long it's been. And then you have to be the one to tell them, like, sorry, there is no legal recourse. You could start an action, but I can't guarantee you a result.
Well, we can't guarantee results, no.
And you better have good evidence and good
Yep.
bookkeeping for the contributions you've made. Otherwise, it's that, you know, extenuating uphill battle,
Yep.
which is just exhausting for everyone.
And it can be draining. It can be emotionally draining. And if it's litigation, you know, we've touched upon this in a few episodes. Litigation is not quick. You know, the wheels of justice turn slowly, and sometimes it's much too slow for people to really take in. You know, this is pretty grim and pretty solace the way we're explaining this. However, common law spouses do have a right to spousal support. So it's not as though you're left high and dry. If you do meet the entitlement for spousal support, you can claim that, which can be necessary, especially if you're going to be litigating or negotiating property rights or, you know, payouts of sorts. Mm-hmm. You do have,
and the law's come a long way, I think, with the support stuff.
It's treated the same.
It's almost the same now as married couples.
Yeah, it's
the
treated the same.
Support
yeah.
is pretty much the same. And you're right. I guess there is kind of a grim tone to what we're saying, but yeah. I don't want to take away the seriousness or the gravity of those decisions.
No, it's still serious. Still a serious decision, yes.
But you're right. I mean, the law has adapted to the spousal support changes that have come into force and recognized common law spouses as spouses for dependent support, and that
Yep.
goes back to our estate discussion, where you as a common law spouse have a right to claim against your deceased partner's estate
Yep.
for support.
Yep.
And so that's been a positive change.
And that's one thing that, talking about the estates, is that when we talk about married spouses who don't have wills, and if one of them were to predecease, you have the preferential share avenue, and you can even make an election under the Family Law Act for an equalization.
That's right, yeah.
So there's two separate things that you can do as a married spouse. If you're in a common law relationship and there is no will, and your spouse or your partner dies intestate, you don't have those inherent rights. No. You have the dependence claim, which is essentially spousal support.
Your spousal support.
Your
claim.
support, but you don't have any claims as against the property. But again, there are unjust enrichment, constructive trust claims. But again,
you're bringing an action against the estate at that point
and it can get messy again.
And this is what Devin, our next guest, is going to talk
Devin Munch,
about.
our next week's going to talk about how estate litigation works and the different avenues people have, and he's going to give us some good insight about how truly emotionally tied and how
difficult,
messy and difficult it can get.
And I think on your point of the election,
yeah,
that's something people need to know about, and I want to leave them with that. I think that'd be a good tidbit to leave people with.
Yeah,
and it's if we're talking about married spouses now. So if you're married and your spouse dies, and there is a will, you have the opportunity within 6 months of death to elect to take an equalization payment, go that avenue, or to elect to take whatever is provided to you under the will.
right.
And that's going to be a discussion you have to have with a lawyer, because if what's provided for you in the will is less than what an equalization payment would be, the estate would be obligated to pay you that equalization payment as long as you elect within the 6 months.
Right. You have to elect within 6 months, and you got to prove your claim.
And you see this more, with intestacy, because typically, because a preferential share was $200,000. Usually the equalization, if there are like RSPs and savings and investments and all that kind of stuff, people would probably decide to take under the equalization rather than the intestacy provisions.
Mm-hmm.
But you have to have a discussion with your lawyer. I mean, every fact scenario is going to be different. Everyone's estate's going to look different. So you just need to be cognizant of those issues. But Matt's totally right insofar as the common law spouse. You don't have that opportunity.
No, and like you had said, it's a claim as against the estate. You have to commence an action as against the estate. You got to retain a lawyer, or you can do it yourself, but it can be difficult to navigate those roads. This is not a simple thing to do. So get a will.
And get divorced.
Get a will, get divorced.
If you're in that situation and you need to be, because it's the cleanest break and the safest avenue to make sure that everyone is protected.
Couldn't agree more.
This episode of Off the Cuff is brought to you by Weaver Simmons LLP, Northern Ontario's largest full-service law firm with over 30 lawyers and 60 support staff. For over 90 years, the law firm of Weaver Simmons has proudly served the interests of Northern Ontario residents and has built its reputation based on exceptional services to its clients. For more information about the firm, please visit www.weaversimmons.com. The link is provided in the description below.
Thank you for tuning in to this rather grim episode.
Oh, come on. Wasn't that bad.
It wasn't that bad. But these are questions that we're getting daily. And with the changes in the legislation, we have to be on top of it.
Yep.
We have to relay that to our clients, but also, that we have a platform we can inform the viewers and listeners about these changes. And it's important.
Yeah, I agree with you.
Yeah.
Because the whole point of the show is to share this information with people, with our viewers and our listeners that don't necessarily have a place to look for it or know where to look for it.
Yeah, exactly.
So that being said, we will put, of course, as we always do,
Yep.
Whatever we talked about today, the links, they'll be in the description. And next time,
I'm so excited.
I'm so juiced for this episode coming
Because
up.
now we talk about litigation.
Yeah, and that's what we do.
Yep.
So we're going to get into it. Devin Munch, one of our associates, going to come in and sit in.
Yeah, he practices estate litigation.
And does some capacity stuff. And I, just as excited as I got over that chicken coop, I am fired up to hear what cases Devin has prepared for us and he's going to come talk about, because that's where, that's where I want to be in court, and I want to hear what he's got. And so, that being said, if you guys have questions for him, drop it in the comments. We love to hear from you. If you have any other feedback or want to just get a hold of us, you know where to find us.
Perfect.
So that being said, thanks for sticking it through. This episode was heavy at times, but necessary.
Thanks for joining us.
Take
See
care,
you next
guys.
time.
Make sure to like, follow, and subscribe to our podcast.
Listen, do what you gotta do to keep us around, okay?